On behalf of On behalf of Bar Council of Maharashtra and Goa, I welcome our today's guest, Advocate Prosper D'Souza sir, and Chairman, Vice Chairman, and all the esteemed members of Bar Council of Maharashtra and Goa. And also, I welcome you all the participants. Today, we have Advocate Prosper D'Souza to guide us on the topic of Divorce Act. Last Friday, Sir has covered a topic of Christian law. Sir has been practicing since last 24 years, and also he has teaching experience of 20 years. Sir has completed his diploma in labor law and cyber law. Sir is an arbitrator and mediator on the panel of High Court of Mumbai. Sir has authored two books, one on TP and another book on SRA. Thank you so much for being here today, sir. Over to you.
It's my privilege and honor to be here. And the other day, I should have taken the names of at least the chairman of Bar Council, Advocate Vivekananda N. Gadge sir, and also I did take the name of Dr. Uday Varunjekar, Vice Chairman, and I should have taken the name of Advocate Jayant Jai Bhaveji, who also knows me well, but I failed to do that. I apologize for that. And there are so many others, like I said the other day, including Dr. Angule and others. I will go ahead with this lecture series because I don't wish to consume more time in all these things. Now, there are some preliminary things which I'm going to say. The purpose behind it is that perhaps with these things, you all may be able to understand or rather uh, appreciate the provision of this enactment in the right spirit. Okay, so therefore I'm making these remarks or making these observations at the outset itself. Later on, if there's a necessity, I will reiterate what I'm saying at this juncture, because this whole topic of marriage, divorce, all these are sensitive issues, and they should be understood in the right perspectives. If somewhere along the way, if I give an impression that divorce is absolutely wrong and that uh, and I take a altogether such rigid position with regard to the stand of the church, then don't think that is correct. Okay, because that is not what I intend to do. Okay. Now, as I said, I will be making some opening remarks. Number one, there are some church documents. Okay, the names are Latin and all that. Church documents, as in those are letters written by the Pope. Okay, they go under different names. One of them is Nostra Aetate. I may not be able to pronounce it correctly, but there are some such letters. There are other letters like Nostra Aetate, I did say, and there is Redemptoris Hominis. Okay, there are letters. Again, you have Ad Gentes, you have Lumen Gentium. I know not a word of it would be understood of what I'm saying, but the purpose behind telling you this is the stand of the church with regard to other non-Christian religions, no, post Second Vatican Council, as they say, is that the Catholic Church rejects nothing of what is true and holy in these religions. That means the Catholic Church acknowledges that there is truth in the other religions as well. And she goes on to observe that Vatican Council teaching goes on to say that the Catholic Church has a high regard for the manner of life and conduct, the precepts and doctrines, which, although differing in many ways from our own teaching, nevertheless often reflect a ray of that truth which enlightens all men. So, Catholic Church is not taking a stand saying that all other religions are wrong. No, that is not the case. Okay, that is one thing I have to say at the outset itself, so that things fall in proper perspective. Now, as far as the topic of divorce is concerned, the Catholic Church believes in Jesus, no, one of the persons of the Holy Trinity, what they call. They believe in God the Father, the Holy Spirit, and Jesus. Now, when Jesus was confronted with this question of divorce, no, he drew their attention of those who confronted him, so-called Pharisees, drawing their attention to something which was written way back in the Old Testament. Testament meaning nothing but covenant, no, kind of a contract, a relationship between God and His people. And he drew their attention saying that God created man in his own image, quoting some book of Genesis. Bible consists of many books. One of the first book is Genesis. He quotes that. And the second, uh, and in the same quote he says, God created man in his image. And he says, in the image of God, he created them male and female. So he's acknowledging that he's created male and female as well. And he quotes another text from the Old Testament, same book of Genesis itself, which is given in chapter 2, verse 24, which says, that is why a man leaves his father and mother and clings to his wife, and the two of them become one body. So it's a belief of the Catholic Church, and after marriage, both become one. This is not to say Catholic Church does not recognize the Divorce Act 1869 or accept the decree of a civil court. Okay, that is not to say that at all. Okay. Again, he tells those who had raised the question that this whole business of divorce was allowed, no, not kind of, do it as such, not a mandate, not enjoining that you will have to divorce, but it was kind of allowed because it says because of the hardness of heart. Okay, he quotes one Old Testament prophet called Moses. Okay, Moses is a character who had delivered the people who were oppressed by Egyptian. He delivered them from Egypt and he was taking them to the land of Canaan. All this is a little bit of background. I know not much of it would be understood, but the short point is divorce was not something which was easily allowed in the Catholic Church. Okay, uh, or rather, it was not something that was allowed at a drop of a hat, I would say. So also in many other religions, I would like to believe that. And secondly, there are truths, as I said, no, it rejects nothing what is true and holy in this other religions, they say. So that is the stand of the Catholic Church. With this understanding, as and when we come to specific provision, I will point out why it is this way and why it is that. It will make more sense when we come to actual interpretation of certain provisions of this Divorce Act 1869. With his opening remarks, I proceed further. At the outset, like any other law, this law also has a preamble, which is not mandatory, as I said, but it says an act to amend the law relating to divorce and matrimonial cases. Okay, so it clearly tells us what this law deals with. Okay, then you have the short title, extend applicability, which says Divorce Act. First of all, it says when it came into force, 1st April 1869, long time back. Long time back, therefore, some courts will say this law is outdated as such. Another reason is there are a lot of things which have happened ever since. Okay. Then, not that there were no amendments. 2001 was when major amendments happened. Okay. Then it says this act extends to the whole of India except the state of Jammu and Kashmir. In some of the commentaries, I don't find them passing a remark saying that ever since the Jammu and Kashmir Reorganization Act 2019, which became effective from 31/10/2019, this is extended to Jammu and Kashmir also. It doesn't say so. Okay. Anyway, but it would be so because of the going of that 370. Okay. But we'll have to take a look at that Jammu and Kashmir Reorganization Act 2019 to have a proper understanding of this part of this section too. Then now comes the little important part, and as much as it tells us what kind of relief can be granted. So I'm on section 2. I hope that you're accessing your bare axe while I'm trying to share some knowledge on this subject. Now, it talks section 2, the second line, rather, the second point talks about extent of power to grant relief generally. No? Then it will say nothing herein contained shall authorize any court to grant any relief under this act, except. Now there is except. So court can only grant relief when that except will tell us. When the petitioner or respondent professes the Christian religion. Again, we come to that word professes. In our understanding, that word is somebody who affirms one's faith in or owes allegiance to a religion or a set of beliefs. So to simplify this whole thing, we would say somebody has some kind of set of beliefs. So he's adhering to those beliefs or following those beliefs, following the precepts, following that faithfully. Then we would say he's professing that particular religion, that particular ideology. So number one, when can relief be granted? When the petitioner or it is open to both. This or part of it was incorporated later. I keep telling the law students whenever they write any exams, if there are any amendments or whatever, they should highlight it so that highlight doesn't draw the attention of the examiner so that it carries more weight. From your optional question type of question paper, you all may also have to you all may have, a need may be felt to look at these amendments as and when they happen. Okay. So now, except with the petitioner or respondent professes the Christian religion, so no relief without that. Point number one. Point number two, and to make decrees of dissolution, okay, or to make decrees of dissolution of marriage, except again where the parties to the marriage are domiciled in India and at the time when the petition is presented, not and at the time when the petition is presented. So point number one, either petitioner or respondent, they should be professing Christian religion. That is the criteria. Point number two, if a decree of dissolution has to be made, parties to the marriage should be domiciled in India. When the petition is presented, there will be case laws on that. At the time you are not domiciled, later on you are a domicile, that does not rectify the situation. Okay, that would be a bad litigation. Then thirdly, relief of nullity can be granted or decrees of nullity of marriage when, except when the marriage has been solemnized in India and the petitioner is resident in India at the time of presenting the petition. Here there are two requirements. Marriage ought to be solemnized in India and additionally, okay, petitioner should be resident in India at the time of presenting the petition. And lastly, to this section 2, it says, or to grant any relief under this act other than the decree of dissolution of marriage or the nullity of marriage, except when the petitioner resides in India at the time of presenting the petition. The latter phrase comes again at the time of presentation of the petition. This petitioner should be resident in India. So what we are saying is petitioner or respondent should be professing Christian religion or come with a semicolon. That means it should either fulfill this condition or should be domiciled in India if it comes to decree of dissolution, or the marriage should be solemnized in India and petitioner should be resident in India at the time of presenting the petition. That is for decree of nullity. Okay. And for granting any other relief, the petitioner should be resident in India at the time of presenting the petition. Now, little more on this. Okay. Now, I have already commented on this, but it needs to be reiterated perhaps in the context of this act proper. The name of this act, the original name of the title was the Indian Divorce Act. It was substantially wrong because it did not apply to all Indians. Okay, it gave a wrong impression, and only Christians were governed by it. And in order to rectify what they did is they knocked out the word Indian, and again this was omitted by virtue of Act 51 of 2001. Okay. Now a personal comment, not a personal comment, as an observation there by some authors saying that they did away with this word Indian. Yeah, what they did is right. But then they should have incorporated the word Christian to make it more evident that this law applied to only Christians. But doesn't seem to have been done. And therefore, that criticism. Of course, this act is a personal law, what we call lex personam. Examiners, the paper setter may be in the habit of asking some Latin terms and all that. So lex personam is nothing but personal law in case it is asked. No? And as I rightly said, it would have been more proper, appropriate, symphonic if the title had been amended as the Indian Christian Divorce Act, or for that matter, the Christian Divorce Act also perhaps would have sufficed. Okay. Moving on, now section 2, as I said, there would be case laws saying the obvious. What is there in the section would have to be reiterated, told again to the parties through some case laws when they take up that very point and approach the courts. One of them is when the courts had to tell them the parties must profess Christian religion. Okay, that is the first point that we observe. Okay. Then secondly, another case law, it says that it is not enough that one of the parties professes Christian faith. Okay. There was this, or other, I'm sorry, it's the other way around. It's enough if one of the parties professes Christian faith. There was this case law where there was a Russian Christian and the husband a Parsi. And here the court said it had jurisdiction under the act to entertain the petition for restitution. It had, because it fulfilled the criteria that one of the parties was a Christian, be it Russian Christian or whatever, parties was a Christian. Then we move on to the domicile part of it. So parties should be domiciled in India, as we said, at the time of presenting the petition. No? And if you have to look at the flip side of it, If not domiciled, then the court cannot entertain that and cannot dissolve the marriage. Okay. Then you have this, if the decree for dissolution marriage is granted by the court which has no jurisdiction, then obviously the marriage which was so-called dissolved by the court which does not have jurisdiction, that marriage would still subsist. No, therefore anybody getting married again during the substance of that marriage, because the court in the first place did not have jurisdiction to pass the decree of dissolution. Therefore, there is no dissolution in the strict sense of the term. And therefore, the marriage subsists, and what the person, if he gets married the second time, that would amount to bigamy as such. That is yet another case law. Okay. That is some Finch versus Finch. Uh, Moving on, never mind the names. I'm told that you all will require all this case law more so during your interview. Okay. By the way, I thought of congratulating those who had cleared their consumer exams, and those who attempted but could not. There are other opportunities also. Okay. Moving on further, uh, in determining the domicile, it seems the domicile of the husband would be sufficient. Why and all that, whether it's right, we can get into a heated argument over this, or rather no argument at all and come to some understanding. But as things stand today, the wife takes the domicile of a husband upon a marriage. No, that is how it is. So dissolution of the marriage, okay, it is the domicile of the husband alone which is to be considered, because the wife takes the domicile of her husband upon a marriage. No? So, and the court would apply the test of domicile as on the date when the application for dissolution for marriage is filed. That is the date that the court would take into consideration. Okay. Then Section 2 is very categorical. It seems that both the parties should be domiciled in India. This is a condition precedent for filing petition for dissolution. Okay, and that aspect goes to the root of the matter. If it is not that, then the whole litigation fails as such. And in another case where the respondent himself admitted that you are domiciled in United Kingdom, therefore the court would have no jurisdiction and the petition would not be maintainable. No? And the question of domicile and jurisdiction that they held was a preliminary one. So it goes to the root of the matter. First that, and then the rest can follow. So that was again held in another case law. Okay. Uh, After the date of application for dissolution of marriage, no, is presented after that date. If you are trying to change to Indian domicile, that will not validate the proceeding, no, as I pointed out earlier. No? What is invalid at that point of time doesn't become valid later on if you try and become an Indian domicile. Obviously, so that is yet another case law. Then, as far as nullity of marriage is concerned, only condition is marriage ought to have been solemnized in India, and petitioner should be resident in India at the time the petition is presented. This is stated in the section itself, and it is reiterated again in some case law. Okay, yeah. Then we move on further. Further, you have about the uh, section 3 interpretation clause or some. This is in 3, mostly it's in 2 that we are aware. Okay, once you know the structure of any law, then we will know how it flows and which provisions to look for where. Okay, this interpretation clause, like any other law, would have that. Many other laws would have that opening sentence which I have commented upon. In this act, unless there is something repugnant in the subject or context, repugnant means contrary, inconsistent, not in keeping with, okay, obnoxious. That is the word repugnant. So we have said meaning that comes from the context prevails over the other meaning, and there are other rules of interpretation which will apply. And there they want us to know that High Court would mean in case of the state, it would be High Court for the state. If it is Delhi, it is High Court for Delhi. And if it is Manipur or Tripura, it would be High Court for Assam. And if it is Andaman or Nicobar Island, it would be High Court of Calcutta. Lakshadweep, it would be High Court of Kerala. Chandigarh, it would be High Court of Punjab and Haryana. And in the case of any petition under this Act, High Court would mean High Court for the area where the husband and wife reside or last resided together, where the parties reside or last resided together. District judge, one who's a principal, means a judge of a principal civil court of original jurisdiction, however designated. He may not be exactly designated as a district judge. He may be called principal judge or whatever. That doesn't make any difference. District court, again, they have defined it. It's there, nothing much to explain there. So in case of petition under this Act, court of the district judge within the local limits of whose original jurisdiction or of whose jurisdiction under this Act the marriage was solemnized or the husband and wife resided or last resided together. Court would mean High Court or the District Court, as the case would be. Case would mean. Then minor children, in case of boys, not completed the age of 16. Case of daughters, who's got native father, the age would be 13 years. Okay, not completed 13 years. Other cases means unmarried children who have not completed the age of 18 years. So minor, many laws, the definition minor perhaps would differ depending on the requirement of that law and how they want us to understand that term as such. When it comes to marriage with another woman, of course, this does not take away this law, which is the Prohibition of Children Marriage Act, 2006, no? And where the age in case of male is 21 and age in case of female is 18 years as such. Then when you talk about marriage with another woman, then during the lifetime of the former wife, if you have some other woman, then that is what they're talking about. That is what the definition says. Okay. Then desertion. We may have a case law or two on this as we go along. Okay. Desertion would imply an abandonment, no, against the wish of the person charging it. Okay. So against the wish, you are abandoning. Okay. Then you have the word property. Okay. It would include, in case of a wife, any property to which she is entitled, and for any estate in remainder or reversion or as a trustee, executrix or administrix, and the date of the death of the testator or intestate shall be deemed to be the time at which any such wife becomes entitled as executrix or administrix. Okay. Remainder, whatever remains after the property is usurped or whatever. Reversion, what comes back. Okay, all these terminology terms are dealt with in your, I believe, Specific Relief Act 1963 as well. There are four definitions: obligation, settlement, trust, trustee. And the last definition, words and expression used here but not defined here, will have the same meaning as assigned to them in the Contract Act. So there they have defined certain terms and they have explained what this, further on they have explained or other these words are even occurring there. Okay. Then you have about residence conferring jurisdiction. So here what matters is when we are talking about residence, there should be merely a casual visit to some place. That will not give a person the right to say I'm residing there. No, if he has no intention to dwell there, be it husband, be it wife, and they have no fixed place of residence there, that will not amount to residence. No, in that place within the meaning of Section 3. Okay, and therefore that will not give that person a jurisdiction to file any proceeding there as such. But it need not necessarily be one, and we are saying casual visit will itself not give somebody a right to say I'm residing here, okay, without the intention to stay there. On the other hand, that intention should not be such that person should be wanting to stay there for an indefinite period. That is also not absolutely necessary. Okay. So on the date of filing the case, the family court, if it has no jurisdiction, then such jurisdiction uh, as we have said earlier, if it did not have jurisdiction, you cannot have jurisdiction conferred on it later on as such. That stands as it is. Now, what do we mean by desertion? We said we'll comment a bit on this. So, desertion would be something which is an active or willful termination of an existing state of cohabitation. Willfully, you're terminating it. Willfully would mean with permission and all that, then that is not willfully, janbujkar. Okay, so willfully you are terminating uh, uh, the existing state of cohabitation. You're not allowing consortium. That was one of the words asked in the options in the previous exam. Advocate Shabana Rizvi had been kind enough to share the question papers with me. So one of the terms that is asked there is, which is the appropriate term? Okay, the consortium, the company of the other spouse. So active or willful termination of an existing state of cohabitation without the consent, expressed or implied, of the party alleging desertion. You don't take consent, either express or implied, and against the wish of that party, and that party voluntarily puts an end to that state, then you will say you have deserted. So impliedly you have consented, otherwise is willing, okay, all of it comes. He wishes that you be separate for some time, then that is no desertion as such. Okay. Uh, there was this case where the man failed to make proper provision for the lady and the children for more than 2 years. Though the wife was prepared to return to him, but he had not made any provision for residence or for maintenance. Then in that case, she declined to join. And the court said she was right. Okay. there was no desertion by the wife, and it was the husband's conduct, no, husband's conduct that constituted desertion. Okay, not the wife's as such, because you have to make it possible for her to come and stay as such. No? So, so also if the husband fails to provide the wife with any maintenance, that by itself is not enough to prove desertion. No, maintaining दिया बोल के he deserted you, that may not be the case. This also was held to another case law. So also obviously, which I have said earlier, if the wife is residing at some other place with the consent of the husband, and then you cannot say that she had deserted him as such. Obviously so. That point gets reiterated to various case laws over and over again. Sometimes advocates keep on taking those points when they contest any litigation, just to maybe prolong the litigation or whatever reason, or they may feel that is really the case in respect of their client. But later on, the court is then rather constrained to observe these things, which are very much there in the section and so very obvious to so many case laws. Okay. Uh, if the parties are living under the same roof, I have one such case where the parties are living under the same roof. Okay, husband and wife. Now, in this regard to this, the parties if they are living under the same roof, then in order to succeed in establishing desertion, you would have to show that they are living as two households. No, chula and all that is alert, the cooking and all that is alert, as two households. Okay, only then you will say there is desertion. Okay. Uh, Also, initial desertion, you cannot say that the desertion will continue when the husband and wife live together. I had one very sad case where the lady says, the husband has beaten me mercilessly, but I don't want to go back to him. I said, in that case, why don't you go in for a mediation, which will help you take a decision whether you should go in for a dissolution of marriage or mutual consent, divorce, and all of that. She said, no, I'm aware all that can be done. But the moment the world comes to know, the world at large, that I'm a divorcee, then they would perhaps treat me differently. So she only wanted to remain married on paper because to feel safe in the society. That is the plight of women. Though she was educated, but she felt that way. That's a very sorry state of affairs if she gets that feeling, which goes to show that this uh, uh, patriarchal society has still not made it safe for the women folk to know that it's okay if some misfortune happened due to some misunderstanding or some deliberate act on the part of either spouse. They have to live separately for whatever reason. That has still to happen. Okay. I'm not trying to be moralist or pontificate, but that was just a passing observation. Okay. And then again, another case law where it says that if one of the spouse by his words or conduct compels the other spouse to leave the matrimonial home, then the former would be guilty of desertion as such, though it is latter who has physically separated from the other. Okay, so one who is compelling other to go, he would be guilty of desertion. He is compelling it, making it difficult, impossible for that person to live. Always there is a question of who deserted whom, whether the wife left on her own or the other way around. That question also always remains. This was in a case which you may perhaps remember because of the name. It's Lovely Thomas versus uh, Tommy Alexander. Lovely Thomas versus Tommy Alexander. It was in the year 2000. Okay. Now we go on to the jurisdiction part of it. Okay. Uh, then here we are on section 4, which uses some Latin terms. It says matrimonial jurisdiction of high courts to be exercised subject to act exception. The actual section begins saying the jurisdiction now exercised by the high courts in respect of divorce, a mensa et toro. Okay, and in all other causes, suits, and matters matrimonial, shall be exercised by such courts and by the district courts, subject to the provisions in this act contained, and not otherwise, except so far as relates to the granting of marriage licenses, which may be granted as if this act had not been passed. Okay. Now, what is the Latin term mensa et toro? I believe you all must have already looked at it since you have been studying since quite some time. Okay. It means mensa et toro literally would mean from bed and board. No? So this divorce, it is similar, akin to a separation granted by a court, whereby a husband and a wife are not legally obliged to live together, but the marriage has been dissolved. Not legally obliged to live together, but the marriage has been dissolved. That is the understanding of that term. But we'll get a better understanding as we go along. Just keep paying attention. You know? Also, some incidental remark. though this jurisdiction is conferred on the district court, it doesn't mean High Court is without any jurisdiction on such matters. It continues to have jurisdiction, irrespective of what is given in Section 7 or Section 8 of the Family Courts Act. If you uh, wish to know why certain matters, Christian matters, are going to family courts and not district courts and all of that, then Section 7, you will help yourself by looking at Section 7 of the, what do you call that, Family Courts Act. It makes it clear that that power is given to your family courts as well. Okay. Family Courts Act, I'm trying to access it and tell you that it is worded jurisdiction. It says subject to the other provisions of this act. A family court shall have and exercise all the jurisdiction exercisable by any district court or any subordinate civil court under any law for the time in force in respect of suits and proceedings of the nature referred to in the explanation, and it goes on and on. I don't wish to take you all to all of it. I'm just trying to draw your attention that virtue of Section 7 of Family Courts Act 1984, the jurisdiction is also conferred on the other courts as well. Okay. Uh, so that's how the matters go to civil court. And you have Section 20 of that same family court, okay, which will tell you that there is this, it's a not non-obstante clause. It will say the provisions of this act, that means the Family Courts Act, shall have effect, notwithstanding anything inconsistent therein, therewith contained in any other law for the time in force, or in any instrument having effect by virtue of any law other than this act. So the provisions of Family Courts Act, which came in much later, 1984, that will prevail over the provisions of override and prevail over the provisions of other acts as such. So Section 7 makes it possible for a family court to take up such matters which are hitherto assigned to district courts as such. Okay, moving on further. Now, uh, uh, if you go to Section 5, okay, Section 5 will talk about enforcement of decrees and orders made year to before by the Supreme Court or High Court. So then they're mentioned in this section of ecclesiastical side. No? Ecclesiastical. Ecclesiastical, it has to do with the church, relating to Christian church or its clergy. That is ecclesiastical. Your mobile dictionary would be good enough to help you. Nowadays, I have a big volume of Black's dictionary. That was an authentic one. Okay, apart from other dictionary. But now that Black's is also available on your Googles, in case to look up any Latin phrases or words, authentic meanings would be there. Now, going on to this section, I mean, looking at this section again, section 5, it says any decree or order of the late Supreme Court of Judicature at Calcutta, Madras, or Bombay, sitting on the ecclesiastical side, or any of the said High Court sitting in the exercise of the matrimonial jurisdiction, respectively, in any cause or matter matrimonial, may be enforced and dealt with by the said High Court, respectively, as hereinafter mentioned, in like manner as if a decree or order had been originally made under this Act by the court for enforcing or dealing with the same. So, it is talking about earlier High Courts which were there, late Supreme Court of Judicature. Earlier, we had the Supreme Court. When you go to CPC, you'll find that all these things said. CPC first, 1859, Sir Charles Wood is credited with that code. 1882, Sir Warrington is credited with that code. And now the history of all of that, that will help you understand this section better. Okay. So, uh, moving on to section 6, it is talking about pending suits. It says all suits and proceedings in causes and matters matrimonial which, when this act comes into operation, are pending in any high court, shall be dealt with and decided by such high court, so far as may be, as if they had been originally instituted therein under this act. So, this act, since it is a very old act, what happens to the litigation? Not very old act. What I meant to say is, though it's old act, but what happened to the litigation which is pending then? These are questions of academic interest as of today, because we are down so many decades now, and it's been quite some time that this law was passed. So at that point of time, this section made a lot of sense, because it should be treated as if those litigation was instituted in that very court. No? So, uh, okay, moving on. Then section 7 is omitted. 2001. So wherever you come across 2001 amendment, take a close look at it. Perhaps that could be one of the questions asked in your exams as such. Okay. May not be really so, but I'm not sure. You could be prepared. Okay. Help yourself with regard to that. Okay. I'm moving on further. That's incidental remark. There's section 7 of that earlier act. What we said is omitted. That section, you can take a look at it to help yourself, but that is of no consequences now. You can simply ignore it, saying that it's omitted as such. But there is commentary on that. So they were not entitled to divorce my mutual consent and so on. The other day there was a query on mutual consent, and the gentleman has shown a lot of patience by waiting for this particular lecture series to happen. Okay, I thought it appropriate to address that question today, and we would be doing that during the course of lecture as such. Okay. Moving on to extraordinary jurisdiction of High Court. Okay. So whenever this High Court thinks fit, it can remove and try and determine as a court of original jurisdiction any suit or proceeding instituted under this Act in the court of any district judge within the limits of its jurisdiction under this Act. So the power to transfer any litigation from one court to another, that is there very much in the High Court. And by virtue of this section, it gets that power. It does not have to advert to your CPC, okay, or that matter your section 45 of this Divorce Act, okay. Section 45 of this very act would say that CPC would apply to subject to provisions, okay, subject to provisions contained herein. Once again, section 45 of this very act, what we are dealing with, would say that CPC would apply. So all the divorce matters, CPC would apply. But it is saying subject to the provisions contained herein. So there is this section 8, one such provision which is contained herein, which says that the High Court has power with regard to transferring matters. Okay. High Court can also withdraw any such suit or proceeding and transfer it for trial or disposal to the court of any other district judge. So this power is there very much in the High Court as given to it by the legislatures as such. Okay. Then with that comment, we move on to section 9, which talks about reference to High Court. When any question of law usage having the force of law arises at any point in the proceedings previous to the hearing of any suit under this act by the divorce district court or any other subsequent stage of any such suit and the execution of the decree therein or order thereon, the court may, on its own, suo motu, on its own motion, or in the application of any of the parties, draw up a statement of the case and refer it with the court's own opinion thereon to the decision of the High Court. So, just as you have constitutional questions coming up before the trial courts and other courts, then it is their duty to make a statement of the case and refer it to the High Court, and it has to give its own opinion as well. Okay, and it has to refer to the High Court. So here, this section talks about if there is any question of law or usage as well. The usage is regarded having the force of law, and therefore they have included usage as such. Okay, and it says very clearly usage having the force of law, not any other usage. Okay, then the latter part of this section, the question has arisen previous to or in the hearing, then the district court may either stay such proceeding or proceed in the case pending such action and pass a decree contingent upon the opinion of the High Court. So it can either stay, it can go ahead, and it can say whatever is the final outcome, what the High Court says about this particular law, question of law usage. Ultimately, High Court's what it decides, that will prevail over whatever it decides. It will be subject to that. Contingent matlab subject to that. Here it is taken in that sense as such. If a decree or order has been made, its execution would be stayed until the receipt of the order of the High Court. Obviously so, because you have referred that question of law usage having the force of law to High Court, then you would have to wait till what the High Court, Honorable High Court says about that. Okay. I've seen of late, this is not to praise anyone, but that's a serious, honest personal observation, that many High Court judges are going out of their way to call the parties in chamber, also in the courts, they are making lots of efforts to see that the parties reconcile or somehow put an end to their, and there are so many litigation pending between them. They have really done a wonderful job. They continue to do so. And parties also, at times, they listen to the High Court judges also. And the matters are getting resolved. That's really very nice because otherwise these matters go on. And it affects not only the parties as in husband, wife, but also the children and also the family members of both the spouses as such. Just an incidental passing remark. Okay. Section 10 will talk about, now some books quote section 10, they give section 10 properly, but I've seen the latter part of that section. By latter part, I mean subsection 2 of section 10, on which a question had been asked in the past. That is missing. So be careful of such book. Careful as in no book is good or bad. Every book will contain the law as framed by the legislature, and it will give you some cases. Only the trouble would be you may be comfortable with some language or may not be comfortable with some other language. You'll lay your hands in authentic books, okay, which are good to, there'll be less of typo errors and maybe other such errors. Now, coming back to this section, they have laid down the grounds for dissolution of marriage. Okay, so though the initial understanding was due to hardness of heart, the divorce was allowed and this and that, but here is a categorical section saying that your divorce has been allowed. Okay, and this section was amended as such. You'll see that the 2001 Amendment Act 51 as such. Now it says any marriage solemnized, okay, whether before or after the commencement of Indian Divorce Amendment Act 2001, may on a petition presented to the district court either by the husband or the wife be dissolved on the ground that since the solemnization of the marriage, the respondent, okay, here the parties are called petitioner and the respondent. Okay, so there are grounds given here. One is that of adultery, the other is of conversion to another religion. The third one is of incurability of unsoundness of mind for a continuous period of not less than 2 years, immediately preceding the presentation of the petition, or the fourth one seems to be omitted. Okay, and that had happened in 2019 itself, 23rd, 28th February. Okay, before that, it spoke about uh, virulent or incurable form of leprosy and all of that, that has gone, in case you need to know. But I don't think that may be so important from the examination point of view. But moving on further, then it lays down another ground where it is talking about if for not less than 2 years immediately presenting the petition, the parties suffer from venereal disease in a communicable form, which can be transmitted, communicated. That also could be a ground for divorce. Then uh, if one has not been heard of as alive for a period of 7 years or more, okay, by person who would have naturally heard of him, okay, if the heard of the respondent with the respondent had been alive, that also becomes a ground for divorce because you have no way of knowing whether the person is still around or is gone and dead, no more. So that also is a ground. Then willful refusal to consummate the marriage, have conjugal relation, that also is a ground. Willful, okay, not by understanding between the spouses. And the marriage has not therefore been consummated. Marriage is not consummated. I've dealt with one case very recently where the parties stayed together before marriage, but strangely, and it seems to be true to great extent, but God alone would know how far that would be true. Parties are not, of course, there was no marriage, so therefore there's no question of consummation of marriage, but there was no physical relationship as such. But it seems so, at least apparently, from what came before me. Okay. So, though it is difficult to believe. Now we move on to another ground which says uh, if fail to comply with the decree for restitution of conjugal rights for a period of 2 years or upwards, after passing of decree again the respondent, so there is no uh, uh, complying of the decree of the conjugal rights. Okay, conjugal rights is parties are told to go back and consume the marriage. Okay, live marital life. Okay, so that is not done for 2 years or upwards. Okay, I was a little not so comfortable with the conjugal rights wala section, but that discussion can happen some other time. Okay. Moving on further, if the spouse had deserted the petition for at least 2 years immediately preceding the presentation of petition, deserted, we have some sense of what desertion is. So moving on, or treated the petitioner with such cruelty or as to cause a reasonable apprehension in the mind of the petitioner, it will be harmful or injurious for the petitioner to live with the respondent. That apprehension is important. Okay. So if the person feels he would not be comfortable and the person just cannot live. It would be so very difficult for that person to live with their spouse. So therefore, this aspect of cruelty has also been made a ground for divorce as such, and it is open to both the parties. But now, as I said, subsection 2 is only available to the wife. Okay, which is wife may also present a petition for dissolution of marriage on the ground that the husband has, since the solemnization of marriage, been guilty of rape, sodomy, or bestiality. Beast, acting like a beast. We are coming to all of that. But these grounds are exclusively available to the wife. This question has been asked in the recent past. Maybe asked, may not be that, I don't know. But any such thing, you'll have to sit up and take a relook at it so that you are prepared for the ensuing exam. Now, Once again, a little explanation while we are here on this divorce aspect of it. And there's this uh, comment in one of the case laws where the Honorable Supreme Court says that the dissolution of marriage is synonymous, similar with divorce, and there is no difference between them. This they say in Zohara Khatun versus Muhammad Ibrahim. That's one of the cases where they had said this. And another term they said, divorce mens et toro. No, Division Bench of the Andhra Pradesh. It had explained that term, and while doing so, it traced the history of Christian marriage in another case law called Amar Hala Hemlata, which is Dasara Babu Rajendra Prasad Vahana Prasad, as a remedy the present day of judicial separation, they said. No? So there they explained this term and they said, divorce without rights thereafter to marry another person while the former spouse still lives. Okay. By divorce, the wedlock is removed and the parties become free to remarry. That's what they observed in this case law as said. There is confusion, anything with regard to this? I will explain as I go along and things will become clearer before the close of the day or close of this lecture as said. Once again, the marriages, the ecclesiastical courts, something to do with the clergy, with the church, those courts, if they exercise jurisdiction over marital matters, no, relying on this canon law and all that, they cannot still dissolve a marriage. To my surprise, one fellow had come to me years ago and he had brought one notarized affidavit on which he believed that he was divorced with his wife because some notary had notarized his affidavit and in the affidavit they had written that the parties are seeking divorce by mutual consent. And he was all along under the impression that he is legally divorced. Divorce don't happen through some such notary or even for that matter through any ecclesiastical courts. Okay. So ecclesiastical courts, courts relating to Christian church or its clergy. Okay. So it has to be done by a proper civil court. Okay. And this uh, sometimes it may not be possible or desirable for the husband and wife to live with each other, and therefore they are given this remedy to live separately without a right to remarry elsewhere because their marriage could not be dissolved. And in this act, there is the section 22. When we come to it, we'll get more clarity on this. Now, it forbids the passing of a decree of divorce, mensa et toro. No? So, bed and board, mensa et toro, that decree is forbidden by virtue of section 22. No? But it allows the decree of judicial separation. On the one hand, judicial separation is allowed, but mensa et toro, no? Separation, bed and board, that is not allowed as such. As we go along, we'll see more of this. Okay. So, original provisions of section 10, I did not take you through all of that because that would consume some time. Okay. But if you're so very curious, you can always look at what was there earlier and what is there now. Such academic exercise helps in the argument and it helps in more clarity of the understanding of certain amended provision as such. Uh, Okay. Give you an example in Workmen's Compensation Act, now called Employees Compensation Act. I had taken the help of earlier law, how things were earlier, and now how things are now, and it really helped me to, fortify my argument, knowing that what it was earlier and how things were now. Anyway, coming back to the discussion. Now, uh, the provisions with regard to all this, what was there earlier, no, those provisions were in a way they were archaic, outdated, they were primitive, they were antiquated, no, highly antiquated, they were stagnant, they were anachronistic, no, they were not in keeping with the changing times. Okay. And more than anything else, more than being archaic, primitive, highly antiquated, outdated, stagnant, anachronistic, they were militating or against the fundamental rights guaranteed by the Constitution, Article 14, 15, and 21. They were opposed to Article 14 because they denied equality between man and woman. No? Not only that, they were quite different from the concerned provisions in other laws. So, what was there in this law in Section 10 was not at par with other laws like your Special Marriage Act 1954, Hindu Marriage Act 1955, Parsi Marriage and Divorce Act 1936, and the why this difference? That classification was not justified as such. Okay. So there was no regional, not justified, there was no regional classification. Therefore, it did not withstand the test of the court, that is reasonable classification. And those outdated archaic provisions had to go and they had to be replaced. And therefore, they were also against Article 15 as they were based on gender discrimination. And they also infringed Article 21 because they denied the Christian wife the right to dignity and fair treatment, so not treated at par with the others. So therefore, those provisions had to be replaced. Okay. Now, what are the characteristics of this amendment which were carried out in 2001? One was divorce, grounds of divorce, they were made very much similar to grounds under Special Marriage Act, okay, under Hindu Marriage Act, under Parsi Marriage and Divorce Act, under the Foreign Marriage Act. So parity was brought as much as grounds of divorce were concerned. Then the grounds of divorce under subsection 1, they were made common for husband and wife. Then this amendment was made retrospective as well as prospective. So parties who were married before the amendment also could avail this grounds of marriage. Okay. Then you had a case law where Madhya Pradesh High Court is granted the relief of divorce on the ground of cruelty provided in Section 10(1) X of that amended act in appeal pending prior to the amendment. So this is a point where we are saying retrospective effect was given in this particular case law by Madhya Pradesh High Court. Madhya Pradesh High Court sometimes is ahead of times because I came across one case where they said under 125 of your CRPC maintenance, they are talking of maintenance. They have amended their law, not the High Court, the legislature amended the law so as to give maintenance to grandparents as well. No, clearly so. That law lays down. Okay. So this is not to say our High Courts are not doing a wonderful job, just to point out some things. Okay. Then the whole provisions, both the district court and the high court have that original jurisdiction for presenting a petition for divorce. Under the present provision, only the district court has its jurisdiction. By virtue of this, the high court is relieved of this jurisdiction to a great extent. Otherwise, they would come in first in point of time to the high court itself. No, high court, as it is overburdened with so much of litigation. Okay, and some are frivolous out of that. Okay. And some are ego litigation, especially marriage and all that. The mediation and all it is made mandatory because most of the matters can be resolved through mediation. But as we know very well, initially when the mediation happened, parties are so much mad at each other and angry, and there is so much of angst against each other that they don't allow the mediator to succeed or rather put in his best efforts, and they will not cooperate, and they will always want to contest the matter for at least couple of years or some, depending on how far wisdom dawns on them, and they come to some mediator later on, and they try to either part as part happily or be together happily, whatever, whichever way they decide. And the mediator does a wonderful job in helping them to take their own decision as such. Okay. Now, uh, if there is obviously, so this case law is so very obvious, it said if there is no marriage under Christian Marriage Act 1872, there is no question of suit for divorce under Section 10. No, it cannot be maintained. So there's a case law to that effect as said. No? Uh, uh, then also going further, I'm looking for the as in what would help you all more from the examination point of view, which section will be more important. Now, if the marriage, for that matter, has taken place under some Hindu law or some other law, then you will not get covered under this I mean, in a divorce act as such. Okay. Uh, when we talk about adultery, no, under the old provisions, this adultery simplicity was the ground of divorce available to husband only. Look at the discrimination which was there. And that was the only ground for him. He could get divorce on any other ground. No, he could not, not even under cruelty, not in the under desertion and all of that. He could not. It was only available adultery, simplicity. On the other hand, divorce was permitted, or rather not permitted to the wife on the ground of adultery, simplicity. So uh, this thing was corrected later on by virtue of an amendment. Okay. So what was required is incestuous adultery or bigamy with adultery or marriage with another woman with adultery or adultery coupled with cruelty or adultery coupled with desertion. Okay. But all this was in violation of Article 14, 15, and 21, as if adultery itself was not enough. All that has gone now by virtue of this amended Section 10 as such. Okay. Now, you may have to help yourself with the definition as given in Section 497 of IPC when it comes to the definition of adultery. Okay. Uh, the matrimonial law, the definition of the adultery is broader than the definition given in your IPC. Their voluntary sexual intercourse by a married person with anyone who is not his or her spouse is adultery. uh, and where there is an appeal against the decree of nullity of the first marriage, okay, party remarries another person, second marriage would be null and void as such. Okay, that is uh, the arising out of some case law. I don't wish to give you the citation of so many cases. There are plethora of cases on all these points. Okay, uh, if this is a, you may want to just, you may somehow remember it what I'm saying. If the person with whom the sexual intercourse is had is not married, then it's a single adultery. If both the persons who commit adultery are married, then it's a double adultery. Not that this is news to you. You all have been dealing with all this laws. Okay. So in such cases, matrimonial law makes both of them as marital offenses. Whereas under 497, sexual intercourse with an unmarried woman, which is known as fornication, is not a crime at all. Okay. Then you have when a woman is raped by a husband cannot file a petition for divorce because she did not consent to the sexual intercourse. She is not guilty of adultery. Obviously so. Okay. Now, there is this petition for divorce which cannot be made on the ground of pre-marriage adultery. Okay. Section 10 contemplates granting of decree of divorce on the ground of adultery on the since the solemnization of marriage. So only it is the section 10 will apply only after the solemnization of marriage and not before that as such. Okay. I hope I'm getting across. Okay, I believe last few minutes have been left for getting clarity on certain things that I may have said or your own question which need to be answered as such. So we take those questions because you all may have been muted right now. Okay. Uh, so if there is any allegation by the husband of any relationship before marriage, no, but after marriage, if there is any such thing, no bald statement by the husband that twice or thrice I've seen the correspondent, that is co-adulterer, dropping his wife on the street corners and all of that. That will not bring the matter in his favor as such. That will not be helpful to him as such. Okay. Then we have also said that conversion of religion, that is also made a ground for divorce. Okay, that is so in other religions, other laws as well. Okay, uh, can the convert one who is getting converted, can he petition for divorce on the ground of his or own conversion? Okay, so it says no. The language of that section, the Honorable Court says no. Language of that section is very clear. It is the conversion of the respondent and not of the petitioner which will afford a ground of divorce. As I had a case where a Christian, practicing Christian, he got married to somebody. That lady, because she was madly in love with him and she liked Christianity. She adopted Christianity after knowing fully well what is Christianity is all about. Later on, he wanted to know about other religion. This lady objected, and there were disputes with regard to this, and they wanted to separate, though they had a child. And the actual bone of contention was that the husband wanted the child to be exposed to the knowledge of all religion, which the wife, who was a newly convert, she did not want that to happen, and she did not want the child to be exposed to other religion. So sometimes such things can happen very strangely, though. Okay. So also one point to be noted coming through some case law, that the marriage does not ipso facto or by itself get dissolved just because somebody gets converted. No, that is well settled by the Supreme Court in your well-known case called Sharla Mugdal case, President Kalyani versus Union of India. Okay. So some 1995 case law, which is well known by you all, and also Lily Thomas's case versus Union of India, that is also well known by you all. So that is some 2000 case. Okay. Uh, yeah. Then what about unsoundness of mind? That unsoundness of mind, that must be incurable. Okay. And medical evidence will be required to prove it as such. Secondly, it must be at least for 2 years, it says, immediately before filing of the petition. Okay. And both the conditions run together concurrently as such. Uh, if the respondent was unsound of mind, was curable in the beginning, but later on it becomes incurable, then the period of 2 years would be counted not from the date when he became a prey to that disease for the first time and was not incurable, but from the date when the disease became incurable. जब से incurable हो गया, तब से 2 years you've got to count. That is what that case law would tell you. As far as venerable, not venerable, I'm so sorry, venereal disease is concerned, it also has two conditions. Those two conditions would have to coexist, as we have seen in the section itself. One, the disease should be in a communicable form, communicated to other, that kind of form it should be. Okay, so something uh, not really desired by anyone. Secondly, uh, of course, it is not required that the disease is communicated to the petitioner. Not so. You may not have to prove that as such. Secondly, the respondent had been suffering from the disease at least for 2 years immediately before the petition is presented. So these two conditions would have to be satisfied as such. Then if you go on to non-consummation of marriage, consummation would mean completion or perfection as such. No consummation. Okay, the actual meaning of it. So, supposing there is some willful refusal to consummate marriage, that is a kind of mental cruelty, and thereby it robs the very marriage of its essence, the sexual pleasure that the parties may be seeking. That it would be robbed, the parties would be robbed of that. Okay. In one of the case laws where the lady herself admitted in a cross examination that she refused to cohabit on account of her husband's behavior towards other women, and she stayed in the matrimonial for a short period of just 6 months and lived separately for 15 years. That amounted to desertion and cruelty as well. And the decree of dissolution, marriage was passed by the lower court in favor of the husband. Because, and the appeal also was upheld in these facts and circumstances. In another case, where the court found that the wife had willfully refused to consummate the marriage, then it had held that it falls within section 10(1), 7 and 7, and that was amounting to willful non-consummation of marriage, and it amounted to cruelty to the husband. I had a case where the wife initially as in, at the time of marriage, she was an air hostess, and she was required by virtue of a job to fly, obviously so, and travel from place to place. And he was trying to tell her to take a posting here itself, which did not happen so easily. But she was also not so keen on getting the posting immediately soon after marriage. Later on, she did want that. But by the time the husband had really lost his patience, and then that marriage was going on the rocks. But then I don't know what happened later on. But she was desperately trying to patch up. So also was he, but it had not worked out initially. Later on, there were still attempts made to kind of reconcile as such. Okay. So then you have what happens if the decree of restitution of conjugal rights is not complied. Okay, and there's a legal obligation when the decree of conjugal rights is passed, parties will be legally obliged to cohabit as such. If he or she still remains away from the society, from the company, from the consortium of the other, no, of the decree holder for more than 2 years, then it clearly implies that he or she is not interested in keeping the marital relations alive or the marriage tie alive. Then, in the fitness of the things, the other party would have to be given a right to obtain divorce on this ground alone. No? Uh, this uh, okay. Here, it seems the judgment debtor he cannot file a petition for divorce, unlike the Hindu Marriage Act 1955, Special Marriage Act 1954, where either of the parties of the decree may seek divorce on the grounds of non-restitution of conjugal rights after passing of the decree. So there's a slight difference there. Okay. Uh, I don't know what this Uniform Civil Code will bring uh, with the changes. Okay, but this is how things stand today. Okay. There, the period which one has to wait is 1 year, as against 2 years given in Indian Divorce Act. Period after which the divorce petition may be filed. There it is 1 year in other laws. Here it is 2 years as such. Slight difference. No? So there is a case law also, or rather, there are specific sections saying so. Special Marriage Act 2721, Hindu Marriage Act 131A, and so on. I don't wish to go into the details of that. Then you have desertion. I've already commented on that. I think I should move on with uh, one case law in the passing, where this wife was admittedly living separately from the husband. She refused all attempts for reconciliation. Reconciliation is coming together as such. There it was held that the animus, Descerendi, her intention on her part was proved, and her husband was entitled to a decree of dissolution as such. So, uh, intention, whether she wants to stay or not, that also matters here. Okay. Then cruelty also, there are cases and cases, a number of cases on this. So I will just move ahead. As I said, all provision husband had no right to get divorced on the ground of cruelty. That you will see in the section itself. So as of today, this case laws may not be so useful to you because the section itself is very clear on this aspect. Okay. Then you have so a number of cases of late, not number, maybe at least couple of them I've come across, where the husband would record the conversation with his wife without a consent and he would present it to the court. It was held to be a conduct which amounts to cruelty as such. Another one is the husband compels his wife to indulge in some kind of unnatural sexual activity, and if she refuses, uh, he assaults her and all that. That is not that is also amounting to cruelty as such. And there are many such actually there are many such cases, okay, which gets covered under this topic as such. Then exclusive grounds of divorce we have seen. If the husband is a sexual pervert, you know, or he wants to satisfy his lust in some unnatural way, if, be it practicing sodomy or some such thing, then obviously he would be guilty of sodomy or cruelty. Okay, there is some case law called Veena Daniel versus Sunil Daniel. Okay, then this is about, yeah. This provision of 10.2, it was challenged before the Supreme Court. One of the cases called Anil Kumar versus Union of India. And the court held that it is violative of Article 14, no, which talks about equality, because that was not available to a husband. That was the argument. Uh, but the petition was dismissed, and the court said that look at the reasoning given, because sometimes you wonder these provisions are lopsided, no, not keeping in mind it's a patriarchal society. Therefore, this reasoning, it was held that in view of that muscularly weaker physique of the women, no, muscularly they are kind of weak, and a general vulnerable physical and social condition, and a defensive and non-aggressive nature and role, particularly in this country they are talking about. And therefore, there is nothing offensive if that ground has been made available to the wife alone as such. So that's what they're saying. It is about 10.2. So justifying the ground, and the court, the Honorable Supreme Court said no, the ground would still be available to the wife alone. And when it comes to the standard of proof of adultery in a petition for dissolution of marriage on the ground of adultery, it is not as strict as criminal case. Criminal case, you know, the standard of proof beyond reasonable doubt, unlike in civil cases, okay, where preponderance of probability we talk about, okay, not proof to the hilt as such as required in criminal. It's either this way or that way in criminal. Okay. Then you have divorce. This questions that come up, divorce by mutual consent. There is a specific provision given in Divorce Act, the Divorce Act 1869, which is in the form of 10A. 10A would mean incorporated later on. Okay. Later on, as in 2001. Okay. Came uh, into effect on 3rd of October 2001. So that provision talks about petition for dissolution of marriage could be presented district court by both the parties to a marriage together, whether said marriage was solemn before or after the commencement of the Amendment Act, on the ground that they have been living separately for 2 years or more, they have not been able to live together, they have mutually agreed that the marriage should be dissolved, then it goes on and on. Okay, I leave the reading of the latter part of the section to you all. Though I might as well take you all to the subsection 2, since I've read subsection 1. It says, on the motion of both the parties made not earlier than 6 months after the date of presentation of petition referred to in subsection 1, and not later than 18 months after the said date, the petition not withdrawn by both the parties in the meantime, the court shall, on being satisfied after hearing the parties and making such inquiry as it thinks fit, that the marriage has been solemnized and that the averments in the petition are true, pass a decree declaring the marriage to be dissolved, effect from the date of decree. Now, little comments here and there on this so that there's more clarity brought in. Okay, this we are talking about Amendment Act 2001. Okay, before this amendment, mutual consent divorce was not permitted to the Christian, 2001. Okay, so this comes in only after 2001. The Supreme Court declined to accept grounds of divorce in some case law called Renault Rajamani was Union of India, even on the basis of Section 7, which was there earlier, applying the rule under Matrimonial Clauses Act, okay, 1973 of England. Never mind that, we need not get into that area. Okay. Uh, Now, for that matter, earlier, even the parties were to agree and have their marriage dissolved, the court would not permit it. And that decree was vitiated and not in accordance with law. So it was held in one of the cases called Susanna versus Yasanna. Yaswanna. Now, this section 10A is substantially the same as in Special Marriage Act and section 13B of Hindu Marriage Act, which many are familiar with. I'm told in officials and district areas, mostly this Christian Marriage Act and the Divorce Act 1869 doesn't come into play. It is not used at all. So there are hardly any Christians there. It really may be so because of the factual reason that not many Christians are there. Okay, but at the same time, from the examination point of view, there are questions being asked on this question. Around 4 questions were asked, I am told, and I've already seen them in your question papers. So yeah, and marks so many will get, but that competitive edge, this couple of marks will make a huge difference between who clears and who doesn't. Now the section 10A, as I said, is substantially same as section 28A of Special Marriage Act, 13B of Hindu Marriage Act, except that the period of separate living required under those acts is 1 year or more against 2 years or more under this Divorce Act. Okay. Now, uh, uh, trial court in some matter had dismissed that 2 years are not lapsed from the date of commencement, that separate living. Parties then filed a writ petition because they wanted to waive that 6 months waiting period and all of that. Court straightaway dismissed the request, relying on that apex court judgment, Anil Kumar Jain versus Maya Jain, and referring to their judgment of M. Krishna Prita versus Dr. Jaya Maukarnath, where it was held that the power to waive this period lies only with the Supreme Court in exercise of its special jurisdiction under Section 142. Somewhere in the Viva, this may come handy. Necessary, we see whether we can meet again for those who clear this written. Many would, I guess. Okay. So only Supreme Court would have that power under 142 and no other court. However, on the other issue with regard to 2 years of separate living before the petition, the court went on to great detail. It discussed how the concept of marriage is indissolvability has transformed, leading to liberalization of divorce laws and all that. And what you observed is really something which we should sit up and take note. They said many a battle has to be fought socially and legally before the concept of divorce by mutual consent was accepted by the polity and approved by the legislature. So before this could be acceptable, many a battle had to be fought by spouses who are in trouble for no fault of theirs. Whoever was at fault, they would know. Okay. And credit goes to the Special Marriage Act 1954, which was the first to recognize divorce by mutual consent in 1976. I don't think such questions would be asked. Anyways, and this provision was added to Hindu Marriage Act in the year 1988. And Parsi Marriage Act and all that, they accepted this later on. And it was only long thereafter, in 2001, that this Section 10A was incorporated in this Divorce Act. I told you my initial comments, that divorce was not easily allowed, and then because of hardness of heart, it was allowed. So to the extent possible, there would have to be made efforts that the parties should reconcile. Therefore, some places you will find 2 years, whereas other laws talk about 1 year and all of that. So to not exactly justify, to give it some rationale, what could be the possible reasoning behind such provision. Therefore, those opening comments were made by me. Okay. Uh, so instead of the period of 1 year of separate living in all other acts, this Indian Divorce Act, as I said, it mandates a minimum of separate living for 2 years only. And these provisions were analyzed, okay, uh, and the court said it was argued on one hand that the right to secure divorce must be reckoned as a basic and essential incidence of the right to life. If a right to marry, I have a right to divorce also. That was the kind of argument meted out. And all circumstances, relevant circumstances were considered. And the court came to the conclusion that the stipulation of a higher period of 2 years of mandatory minimum separate living under the Divorce Act applies in contradistinction to those similarly placed, as in a lady of Christian lady and some lady, a Hindu lady or a Parsi lady or some other lady of following other faith. Okay, they were not equally treated as such. Okay, So let's say Hindu lady, 13B would apply to them, not equally. Therefore, it held that this stipulation of 2 years can be read down, it says, READ, read, TOWN, to 1 year. So instead of 2 years, you can read it down to 1 year as such. Okay. uh, Now, in this case which we are talking about, Soumaya and Thomas, the court read down the period of 2 years to 1 year, and it held the stipulation in Section 10A of the Divorce Act that the parties must have been living separately for a period of 2 years or more is declared to be unconstitutional, as the stipulation of period of 2 years therein violates the fundamental rights to equality and the right to life under Article 14 and 21 of the Constitution. I don't think I came across any question in your question paper saying that so and so thing was held in so and so case law. Such a question has not been asked, but I don't see why the examiners may not ask such a question. So, even though I'm told that case law's question will come up only during interview, but I'm not sure whether it would be that way always. You never know how the question pattern would be. So, always be ready for the worst, and which popular case law or which landmark case law says something on a certain aspect of law. It's better to know that initially itself at the time of writing your initial paper. Then further, when the court went on to hold that to save the provision to avoid the vice of unconstitutionality, the period of 2 years stipulated in 10A is to be read down to a period of 1 year. So in effect, this 2 years has become 1 year as such ever since this Soumaya and Thomas's case law as such. Okay. Now, I'm moving further on. I'm just accessing my barak to help you further. Now, further on, Supreme Court 10A1, Justice, uh, some cases they will issue notice, they will call for says of the parties, and all of that is there. Okay, I wish to skip a number of case law. Then I'm stuck, and uh, there is this terminology which we use very often. Okay, where we say that the marriage is broken down irretrievably. Just as we say irreparable harm, loss, damage will be caused. Similarly, irretrievable breaking down of marriage, that is no ground for divorce under the Divorce Act as such. That was held in one of the case laws called Linesh P. Matthew versus Muthula Matthew as said. Okay. Nor any other personal law statute. Therefore, even if a divorce is granted by any English court on this basis, Indian courts cannot recognize and enforce that in India as such. That was observed in yet another case law. Okay. So, uh, there are so many commentaries available. Then you have section 11 talking about adultery or adulteress to be correspondent. So whom to make parties, whom not to. That is the preliminary things who are to be made party. No? So the section is there. I'm not taking you to the whole of section. But then essentially what it says is the adulterer or adulteress, they have to be made correspondent as such. When it comes to a petition for dissolution of marriage, it is presented by husband or wife on the ground of adultery. This ground is available to both, that we have already seen. No? So, so wife could be living a life of prostitute, or the husband could be living an immoral life. All that is there. Okay, provided there. Okay. Then we move on further, which is there the case laws to every section, detailed explanation is also there. Then there is no collusion between the parties. That is also mandatory statement which we make in such litigation. So, Mile Bhagat, I've seen one litigation, I've been handling that case, where the mother very cleverly says she files a civil suit to throw out her son. No, actually, she didn't really want to throw him out, but on paper, she wanted to show that I'm throwing out my son, and with the son goes the daughter in law also. Therefore, I gave nothing of the shared household to the daughter-in-law. That was the intention. And the civil sued innocently because the other side perhaps failed to point out to the court the collision which was there. And they get a decree in their favor, which is not disclosing the true facts to the court. Court is misled into giving such a decree. But that is still under challenge, and further on, the parties will be perhaps exposed for having done such a thing. Now, moving on to section 12, the court would have to be satisfied of the absence of collusion. I've already given you some understanding about this collusion part of it. No? So there should be no collusion as such between parties as such. No? Uh, this obligatory on the court which entertains a petition to consider all the aspects of the case, which are mentioned in the section and in section 14, further section, and that obligation would not get extinguished merely because the case remains undefended. It's like in the civil case, if the other side is not contesting, it doesn't mean the plaintiff gets a decree in his favor. Court may still want the party to prove certain things. Okay, so that is what comes across to that commentary and case law, which we were just talking about. Moving on to section 12, I've just, or rather, uh, uh, I've already said the section 12 and 13, there they are talking of satisfaction. There the satisfaction would mean on preponderance of probability, as in civil cases, and not something which is required in criminal case beyond a reasonable doubt. So if you wish to, this comes across to a case law called Pasumpen Gandhi versus Shirley Gandhi. Pasumpen Gandhi versus Shirley Gandhi, 2003 it was held. Okay. Pasumpen Gandhi versus Shirely Gandhi. Okay. The uh, proof required is that of preponderance of probability. Then you move on to section 13, which talks about dismissal of petition. So on the evidence in relation to any said petition, if the court is satisfied that the petitioner's case is not proved or not satisfied that the alleged adultery has been committed, number of things they are find petitioner during the marriage accessory to a conniving, going to the said form of marriage or adultery of the other party, or has condoned the adultery complained of, condoning of adultery. In spite of knowing adultery, you go and have relation with the husband. Okay, all that is in a way condoning. You're forgiving in a way, if you wish to use that word. Okay. And the petition presented to the prosecutor in collusion with either party. Then in any of those cases, the court will dismiss the petition. So mind you, if there is any such collusion, it is the duty as an officer of the court to bring it to the knowledge of the honorable court that such a thing is there. Moving on to section 14, we talk about power of court to pronounce decree for dissolving marriage. So where the court is satisfied on evidence, evidence meaning pura trial hone ke baad, adjudication. Kind of, the case of the petition has been proved. So number of things are given there. Petition has been in any manner accessory to a conniving, okay, or adultery of the other party to marriage, or has condoned the adultery, or petition presented a prosecuting collusion, or that, then it would pronounce a decree declaring such marriage to be dissolved as such. Okay. Then moving ahead for the sections that are there before you. Any important comment that wish to be made that I will make that will serve your purpose as such. Then you move on to uh, unless there is conjugal cohabitation, uh, that condonation, the word condonation is also explained towards the end. So no adultery shall be deemed to have been condoned within the meaning of this act, unless where conjugal cohabitation has been resumed or continued. You will say it is condoned only when conjugal cohabitation has been resumed or continued as such. So that explanation is very important. Okay. And that says is all. Then you have 15, relief in case of opposition on certain grounds. Okay, if the suit is filed for dissolution marriage, and if the respondent opposes the relief on the ground in case of that suit instituted by husband, adultery, cruelty, desertion. Okay, such case the suit instituted by wife on the ground of adultery, cruelty, or desertion. Court may give to the respondent on his or her application same relief to which he or she would have been entitled in case she had presented the petition seeking such relief. A respondent shall be competent to give evidence of or relating to such adultery, cruelty, or desertion. So very thing what one alleges against the other side also starts alleging against the other party as such. Okay. So what we are trying to say is also borne out by some case law which says response to some petitioner's petition, which would be competent for the respondent to bring cross petition, not by separate petition on a separate document, but by a further statement added to the original defense to the petition. Unlike your civil matter where you have a counter claim, okay, order 6 is about your pleadings and all that. So CPC, when you go there, you have to file a counter claim. This such a your counter allegation need not be in a form of a counter claim. It could form part of that original defense to the petition itself. This is said so in a case law called Rose Hill versus Luke Luke Hill. Okay, so very old case law, but that is settled law as such. Okay. If a further charge of adultery, further charge of adultery has to be further charge of adultery has to be added. That can be done. Okay, amendment could be allowed. Civil matters, you are very well aware, number of amendments could be allowed. Okay, on the conditions which are there. Then you have section 16, decrees for dissolution to be nisi. Okay, nisi is kind of conditional. So I will not take you to the full section, that may consume a lot of time. But decree nisi is only a conditional decree, does not change the status of the party. Parties would continue to be husband and wife till a decree is made absolute as such. So what is nisi? I don't expect this question, but then one has to be prepared. Decree nisi is a kind of an imperfect for a specified period. No? And the affected party within that period, it can challenge it, no? And it may, by bringing to the notice of the court, cognizance of the court, any material facts which were not brought before it, it can even on the charge of collusion between the parties, all those could be brought in when decree nisi is passed. No? Uh, Under section 16, petitioner has to move the High Court to have the decree nisi made absolute, and he must file a petition on uh, if he that would be dismissed. Okay, on the pain of dismissal of the suit, it says. Okay. Now, full period which is given by the Act, that would have to be elapsed before that decree nisi for divorce would become absolute. There are case laws to that effect. Then another case law would tell you whether on the death of the respondent after decree nisi, this is very interesting. I don't know whether important or not, but it's interesting. What happened after the death of the respondent? No? And pending confirmation, decree nisi is passed. It is subject, not absolute. Okay, it is a conditional decree. Meanwhile, the party dies. What happens? Court held that the suit would abate and it would have no jurisdiction to make that decree nisi absolute. So the party himself has died as such. Okay. So that is a short point in that case law. Then you have section 17 talking about power of High Court to remove certain suits. We have already mentioned this earlier. Okay. So you can take at the earlier provision also. Okay. Earlier uh, decree of divorce which was pronounced by district court, it would not take effect until it was confirmed by the High Court. It was kind of an anathema, which was not called for, not required under the Indian Divorce Act. And that validity of that section was rightly challenged on the ground that it violated Article 14. Okay. So a bench of 3 judges has heard that, no, whether confirmation of decree of nisi for dissolution marriage granted by district court, whether that is required. And to cut a long story short, it was held that it is not an unreasonable differentiation and the section does not violate Article 14 of the Constitution as such. But the Parliament omitted that provision requiring the confirmation by the High Court of the decree of dissolution marriage passed by district court. Okay, so 2001, that requirement itself was taken away by virtue of the amendment as such. I hope I'm making myself clear. So no confirmation required by High Court because of the amendment in 2001. I'm glad I got across this very fast. Otherwise, sometimes it takes a little longer. Now, this is a classic case, kind of a landmark case law, where Molly Joseph versus George Sebastian. Here, the question came up. I had asked this question to one of the lordships in one of the seminars because it was not clear to me then, or rather, I may not have looked at the books properly, whether the divorce granted by the so-called ecclesiastical courts, no, the courts pertaining to clergy, the Christians, and all the tribunals, okay, marriage tribunal, whether their decree would be valid decree, binding, and all of that. And the answer given to me was very clear. This canon law, the personal law of Christians, it can have theological or ecclesiastical implication to the party. But ever since the Divorce Act has come into place in force, a dissolution or amendment granted under that personal law, it cannot have any legal effect. As statute has provided different procedure and a different code for divorce or annulment. So once the law of the land has made it very clear that it will not accept a decision of a tribunal or the canon law, the personal law of the Christians, then that will not stand. And the law of the land, which is laid down in this Divorce Act 1869, that will prevail. So that personal law, it further on they went on to say in this case law called Molly Joseph, which is George Sebastian, that personal law stands clipping of that to the extent statutory law has stepped in. So to the extent that the statutory law has come in, that part of the tribunal, the ecclesiastical courts go away as such. And this was required to be reiterated, retold again in some other case laws also. There was some PIL filed by some advocate belonging to some Catholic association of Karnataka demanding legal recognition of canon law as such. But the PIL were dismissed by the bench comprising of Justice Kher and Justice Dr. D.Y. Chandrachud as such. Okay. Divorce which is recognized, the defendant had divorced the petitioner plaintiff by some customary law before marrying another person, that marriage would still subsist and is still considered to be a married person. Strangely, you will find the parties, common man is not clear with regard to so many things. I give you example on the divorce happening on a affidavit. There are because he gives in writing that he will divorce his first wife and marry her. There are also misconceptions in the mind of common man, and the burden is on us to create awareness with regard to all things, so that there are less problems with regard to all such things in the society. Okay. Uh, yeah. Then obviously this customary divorce among Christians or Indian Christian that was not recognized as such, that was held in yet another case law. Okay. So I've already said that this uh, uh, confirmation by the High Court of the decree Nisi prior to 2001, that has gone now. It has to give way to procedure in Family Courts Act after it came into force in the Maharashtra. Thus, a decree of dissolution passed by Family Court, it would require no confirmation by the High Court, and it is subject only to the appellate jurisdiction of the High Court under Section 19 of the Family Court, and not subject to confirmation under Section 17 of the Divorce Act as it stood prior to amendment of 2001. I'm going at a fast pace, I know, but I hope I'm being very clear in what I'm saying. So ever since 2001, no need of confirmation of the High Court, but if there's a remedy of appeal available to you, statutory remedy, you can always avail that remedy as such. Okay. So now we move on to section 18, which talks about petition for decree of nullity. So it could be presented by either husband or wife to the district court, praying that his or her marriage may be declared null and void. Okay. Uh, Now, there are grounds of decree given there in section 19. Decree could be made on the grounds given there. Okay. It is important, or there are prohibited degrees of consanguinity. Now, consanguinity, whether natural or legal or affinity, all these terms, terminology is not explained in this Divorce Act, or rather not defined in the interpretation clause as given in section 3. We have dwelt on that section 3, and we have seen it is not found anywhere there. Therefore, how do you understand consanguinity would be of the same blood? Okay, linearly you would say father and son. If you're talking of collateral consanguinity, it would be common ancestors, as in between cousins. Okay, and when you're talking about affinity, you're talking about relationship not by blood but by marriage. So that is affinity. Once again, consanguinity, it is of the same blood. Okay, linearly, if you're talking about then father and son, okay, lineal descendant, they are of the same consanguinity. And when it comes to collaterally, it is common ancestors. It could be of cousins. Why are we saying all that? Because grounds of decree, it says such decree may be made on any of the following ground: that the parties are within the prohibited degrees of consanguinity, whether natural or legal or affinity. Some uh, information, that a bit of information which may not be available to people of other faith other than Christian. That is, if there is any such degree of consanguinity which is doubtful, then the parties go to an authority which is higher than the priest, so-called pujari, called bishops. They will approach him and they will seek the permission. And the bishop will have his own rational and reasoning, and he will see whether it satisfies certain condition. It could be a blood test and so on, and then he will grant permission if permission is required to be. It is can be granted, or otherwise he will reject that permission as such. No? Also, the ground given there is if the party were lunatic or idiot at the time of the marriage, former husband or wife, either party were living at the time of marriage. All these are grounds for the decree of uh, grounds of decree as such. Okay. Now, moving further, uh, if the I keep reiterating this point. If the party's marriage is not solemnized under Christian Marriage Act, then the provision of this Divorce Act will not apply. To your surprise or for your information, or you may be aware, it's good to reiterate this point, that some parties choose to get married under Christian Act, and again to go and get married as per Hindu rites and ritual, and they complicate things for themselves. But at the end of the day, if at all any such complication happen, one would have to see whether the spouse has really abandoned his faith. Okay, one of the ways to know that he has abandoned his faith is if he gets married under by as per rites and ritual of some other faith, then his clear intention is seen in the rites and ritual that is undergoing. So that could be a ground as well. Okay. If you read section 18 and 19 together, they are in fact required to be read together. 18 would permit the presentation of petition for getting marriage declared as null and void, and 19 would lay down the grounds for that relief as such. So 2001 has amended both that section by omitting the word High Court in section 18 and in the last paragraph of that section 19. So thereby this High Court is relieved of the original jurisdiction in such matters as such. Okay. I will move on further. Um, so earlier one could present a petition directly to the High Court. I remember one case, a very unique case, where Christian parties they had got divorced in the High Court years ago. I put in nearly 24 years of practice, and even before that, I was working for 21 years. Earlier, in the lady advocate, and I think Advocate Anushka or someone introduced me. She said that I did not disclose much of my information because I did not want to waste much time doing that. But I remember from experience that when Christian married, they got divorced. And after that, saner counsel prevailed and wisdom dawned on them perhaps, and they wanted to reconcile. In spite of the decree of divorce, they reconciled, they stayed together. After that, they had yet another child out of that marriage, and they lived happily ever after. Okay, so that was a unique case. After marriage, the courts having pronounced divorce, they are staying together. I know of other cases also, at least one more case I know, where the court is talking about uh, parties, court is under the impression parties are not staying together, but they have just approved the court and they are seeking divorce from the court, whereas they are living under the same roof and there is no separation as such in the rooms. Uh, Moving on, we have already seen uh, the grounds which are given there in section 19. It in fact lays down the ground for nullity of marriage, but it does not make the marriage void ab initio. Ab initio, a terminology which we are familiar with right from Mori Bibi's case, minus contract is void. Ab initio from the very beginning itself. Ab initio. So 19 provides for 5 grounds of nullity of marriage. Each of them is complete in itself without this other, no? But the so you can take alternative pleas as such. Okay, the court does not preclude him from doing that as such. No? Petition would still be sustained on any of the remaining pleas, even if one of the pleas goes. This is not to advise that you should be taking as many pleas as possible, only taking as such. Also, impotency, the wife, if she, this is a ground which is taken, I'm sorry to say, but perhaps it could be at the instance of some advocate who perhaps misguide the client to take up such a ground of impotency. And then later on, when it comes to mediation, I'm also, as uh, told, introduced earlier, I'm also on the panel of High Court, the mediation panel and the arbitration panel. I find the parties, when they have made some such allegation of uh, impotency, that the offends the spouse so much, the husband so much, that thereafter he is not easily ready to reconcile and patch up with the other spouse because the serious allegation coming from the party or the advocate, one doesn't know, God alone would know. But that makes patching up a little difficult as such, just for information. So one has to be a little careful. I remember one particular case known to me. I refused to immediately uh, shoot a notice to the other side at the instance of the party known to me. I said, hang on, wait, give it some try, give some chance, try to reconcile. And thank God I didn't shoot a notice at the instance of the person known to me. And because of that, the marriage was, I mean, they patched up together and they lived, I mean, they are continue their married life as such. Okay, sometimes while allegation and false allegations, allegation made in notice, which are not sustainable in law and which are not true, could destroy a marriage forever. This is not to moralize, as I keep saying, not to pontificate, just to be sensitive to such, be it Christian marriage, be it any other marriage. We are dealing with human beings, and we are dealing with their emotion, and we are dealing with their, maybe whatever petty quarrel that may have happened. At times, ego, most of them could be ego issues as such. I have had parties who have come to me just because the husband did not take the side of the wife when the mother-in-law and the father-in-law was scolding her. The husband did not stand by her. That itself became a ground for her to divorce the husband. Another strange case which I wish to share, taking advantage of this forum, is where both the parties, both were BTech, both were highly educated, computer engineers and all of that, and both wanted to go divorce because the mother of the husband said the operation cesarean should happen on so and so day, on 15th, and the wife's mother was saying it should happen on 16th or whatever, some other day. And being a patriarchal society, the husband's mother's wishes prevailed, and the operation happened on 15th. And because of which, according to allegation of the wife and her relatives and mother and father, the child died. Not though they were highly educated, neither of them bothered to have a post-mortem report looked at and seen what was the real cause of the death of the child. So parties could be so misguided and so unaware of the realities of life, and they would refuse to understand, and they would go by their emotions. So you need to be a little sensitive, and mediation is the way out of all this difficult situations, I feel. That is my personal opinion. Moving on, sometimes there is a terminology called mental impotence. Let me explain this. No? Whenever this mental impotence is alleged, no, evidence in the form of this medical testimony, that would be necessary. Mere fact that one of the spouses feels that there is no charm in marriage, that she is not inclined, or rather she is inclined towards some religious life, no, that itself is not conclusive on the point of impotency. She cannot say, I feel like now becoming a religious person. That would not be good enough. Though disability arising from mental or moral causes, that would be sufficient. In one case law called Anthony versus Francis Carr, Kerala High Court, it held that the reason for impotency may be physical or it could be mental as well. If the respondent refuses to have the sex with the petitioner because she believes that sex is sinful and hates it, though physically not unable, but mentally determined not to have sex, the full bench held that is a case of mental impotency. Physically capable, mentally she doesn't wish to, then it's a case of mental impotency. This is a further development, or rather, going by this. This is though this is quite old now, 1988. This was held. No? Then the full bench of Kerala High Court again held in another case that where the respondent lived with the petitioner for about 17 days, but did not allow him to have physical relations with. She had aversion for that sex, wanted to be a nun. That was a case of mental impotency of the respondent. Okay. And the respondent may be impotent qua the petitioner, only vis-a-vis that petitioner, in particular and not in general as such. Okay, that possibility is also there. That is yet coming across to another case law. It is V wife versus S husband. Parties' names are not disclosed. This was in the year 1995. It was a Bombay High Court case, page 247, 246 as such. Then prohibited degrees of consanguinity. I've already commented on that. And a little more if you wish to. Consanguinity is itself created by that canon law as such, so far as the Roman Catholics are concerned. The parties are related by consanguinity in the second degree. That per se is an impediment to marriage, but under the canon law itself, it is dispensable, can be removed by dispensation. Dispensation is a permission which is given by the higher authority, which I told you earlier. Bishop can grant dispensation and the parties can go ahead and marry. He doesn't just grant like that. He looks at the uh, so many things and then decides whether to grant the dispensation or not. Okay. With regard to lunacy or idiocy at the time of marriage, that is what matters, whether the person was insane at the time of marriage. Some subnormal intellect, okay, if a person, let's say the wife suffers some minor psychological problem because of a aged father's sickness or any such thing, then that plea of lunacy could only be an invention of the petitioner for securing decree of nullity of marriage. Sometimes these are so very sensitive things. I had one case where one party was staying in Ghatkopar, those familiar with Bombay would know, and the other party was staying at Borivali. Husband had a shop at Borivali, and the wife had elderly parents at home. And the wife was saying, "You come and stay with me," and he was saying, "You come and stay with me." Both were otherwise okay with each other. The only thing is, she was unable to give more time to the husband, and that became a bone of contention. Okay, sometimes this such things also could happen. Okay, so wife is torn between looking after their own parents, or it could be the man torn in between looking after the parents and giving enough time to the wife. That could be a situation. All these are sensitive matters which are very beautifully dealt with by our Honorable High Court, but by so many judges. Uh, I don't wish to name them, lest there is a discussion on that itself. Okay. Yeah. Uh, then moving on further, there are case laws and case laws. Okay. Obviously, if the consent to marriage is obtained by force or fraud, then the marriage will not stand as such. Okay. Uh, uh, if the wife's consent to marriage is not voluntary, and yet we see so many marriages are taking place just because the wife has to give in to the influence of the parents or avoid and escape their wrath or disagreement or under theirs or any other kin's threat to harm themselves or disagreeing party to marry to the marriage or through the imploring of saving the honor of the family or parent satisfaction. In all such cases, the consent would lack. I know of one case where the girl tried to commit suicide because the parents would not allow her to marry. Afterwards, the mother threatened her that she would commit suicide if she did not get married to the some other boy. No, so sometimes the parents play spoil sport in love affair, if I may say so, at the cost of incurring the wrath of so many parents. But uh, yeah, that is how things are in some of the cases. To be on the safer side, okay, yeah. Then in another case, uh, if the husband misrepresents that he's a bachelor, these days online cases, many marriages are happening online. I We were like kind of encouraging one lady to get married because she was all by herself. She had lost a parent, no relatives nearby, nothing, and we felt in her old age she would need some companionship. And listening to her, we never told her to go online, but she of her own she went online, and she was about to get married to a man who was already married, a Christian lady though. And luckily, she was saved in as much as she learned from some source that man was already married and he was trying to fool her that he was a bachelor, and she would have been taken off for a ride, and she would have been fleeced of her property and all of that. Okay, so when the man represents that he is a bachelor and all that, the marriage would not stand there. Bombay High Court has held that. Now look at this, little difference in the High Court's decision. Here, in one of the cases, Bombay High Court held that obtaining consent of the bridegroom on misrepresentation regarding the moral character or virginity of the bride does not amount to fraud. This is what Honorable Bombay High Court has held in a case law called David alias Balasaheb versus Kalpana alias Mai. Okay, that is what. But on the other hand, the Kerala High Court has held in Jomon versus Mercy John that when the husband petitioner was given impression at the time of marriage that the respondent was virgin and was leading a moral life, whereas she was pregnant at that time, the consent of the petitioner was obtained with willful separation of this fact, which constitutes fraud. Of course, the facts slightly differ, and therefore, I believe both the high courts have justified enough. And as we are aware that any judgment, if you go by the definition of CPC also, which is applicable to all this, the definition itself will tell you, Order 20 will also tell you that reasons have to give it for any judgment. And reasons would tell you why this judgment is so. Bombay High Courts as well as Kerala High Courts. Okay. Reason judgment. Okay. uh, then uh, if the marriage is declared null and void under Section 90, then the final decree no, would be drawn up forthwith. Then it would not be necessary to make a decree nisi in the first instance and then make a final decree. So this obviates the need to make a decree nisi, a conditional decree as such. Okay, this was held in Snow versus Snow. So marriage cases, many times you'll find similar names like Balfour versus Balfour, as in contract, if many would remember. So similar cases, very unfortunate to know that parties are warring against each other. Once married, once lived, and one shared household together, and other things together. But for some reason, misunderstanding mostly, so they had to part. Then, therefore, this confirmation of decree, we have said, what was an anathema, not required to be done by the High Court, we have already said. Now, the children of annulled marriage, okay, Section 21 deals with it, okay. So, children begotten, the most affected party are the children, and very sad to say, sometimes we say husband will get visiting right, wife will get visiting right. I had one case where the lady, she was also pursuing law later on. She had, admittedly, she was telling me she had made a mistake by suspecting her husband's character, and therefore husband was very stubborn, and the children were with the husband, and they were he was doing a good job of raising them, but he would not accept the lady for a long time. I don't know what happened thereafter, but it was a sorry state of affairs that the ladies only suspected initially, and the husband took it very seriously and would not even accept the apology of the wife later on, that uh, uh, she had mistaken about she was mistaken about his character. So children are the most sufferers in this. So marriage, if it is annulled on the ground of the former husband or wife living and is adjudged that the subsequent marriage is contracted in good faith and with the full belief of the parties that the former husband or wife were dead, or in the marriage is annulled on the ground of insanity, children begotten before the decree is made shall be specified in the decree, shall be entitled to succeed in the same manner as legitimate children to the estate of the parent who at the time of marriage is competent to marry. So children's rights are protected. Okay, right to property are protected. One would have to take care as a judge to pass orders taking care of the children's rights. Their interests is paramount, no? So that has to be kept in mind all the time. Okay, and the courts are doing a wonderful job doing that. Then once again, Section 22, which we have already mentioned, we have already said meaning of mensa et Torah comes again in this Section 22. Okay. So I don't think we need to dwell on this much because I've already clarified. Okay. And uh, petitioner, but one of the cases tells me that the petitioner cannot claim to treat judicial separation as divorce as such. So if you keep that case law in mind, it would be perhaps helpful. Okay. So that is Thomas Kuriakos versus Abraham Mary, somewhere in 2002. So I'm just giving the what was held as such because for want of time. So judicial separation, it will have the effect of divorce. Hence, he is entitled to declaration to that effect. But the petitioner cannot claim to treat judicial separation as divorce. That is what was held as such. Then non-cohabitation after separation decree, no ground for divorce. That is coming across to various other case laws as such. Even after Amendment 2001, while failure to comply with restitution decree for 2 years. Okay. Now, now just note this. Even after the amendment of this 2001, if there is failure to comply with the restitution decree, okay, for 2 years or more, okay, that is a ground entitling decree holder to seek divorce, okay, but non-resumption or of cohabitation after separation decree is not. Non-resumption of cohabitation after a separation decree is not. Okay. I don't know whether this needs explanation. Once again, I will repeat. I am saying that even after the amendment of 2001, no, failure to comply with that restitution decree for 2 years, okay, that or 2 years or more, no, that could be a ground entitling decree holder to seek divorce. But this non-resumption of cohabitation after separation decree, that is not. That is not. Okay, that comes across to the section also. Section 23. Okay. Application for separation made by petition. That's how you will make. No? If there is no ground why that application should not be granted, then it will be granted. Decree for judicial separation would be granted. Okay. So earlier, as we keep saying, both district court, high court, they had concurrent jurisdiction before the amendment 2001. Now, high court is relieved of that amendment of that uh, task. Then you have section 24, separated wife is deemed spinster. Deemed spinster with regard to acquired property. Deem is a legal fiction. In reality, she is separated. She is not yet a spinster in the real sense of the term, stricto sensu. But in law, she is regarded as if she is a spinster, and if, therefore she is entitled to all that property, no, as if she was unmarried woman. all that is mentioned in your section 24. So also section 25 will talk about separated wife deemed spinster for purposes of contract and suing. Okay, all that whatever contract she enters into is of her own volition and she would be liable to it. Okay, uh, that is what. And there is section 26. It also talks about decree of separation obtained during absence of husband or wife may be reversed. So if you're able to justify why you was absent, just as you restore a suit. Okay, similarly, if it is pronounced at the time he was not there, if he's praying for reversal, you have to show why he was absent. You would have to give a reasonable excuse, not give. There has to be a reasonable excuse for that alleged desertion based on which that separation was granted, where desertion would have been a ground for that decree as such. If the court is satisfied of the truth of that allegation, then that reversal will happen, but that reversal will not prejudice or affect rights or remedies which any other person would have, uh, 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 which would have accrued to him as such. No, that would not get affected. No? So, yeah. Uh, it's for the other side to show how it was the fault of the petitioner and that fault is not excusable. Okay, whether that he had not taken proper steps and all that, that is a matter of detail. We can leave that. Then you have this protection orders which comes in your section 27. Deserted wife, she could apply to the court for protection as such. Anytime after desertion, she could ask for protection of any property which she may have acquired or may acquire, and any property of which she may have been possessed of or may become possessed after their desertion against a husband or creditors, any person claiming under him. Section itself is very plain and clear. So no further clarification perhaps would require. When they're talking about only clarification is the beginning of the section 27, I hope you all are accessing your barrack. It says any wife to whom section 4 of the Indian Succession Act 1865, it is making a reference to the old Indian Succession Act. Okay. So that section 4 of that old Indian Succession Act, which is about interest or powers not acquired nor lost by marriage, that is equivalent to section 20 of that new Indian Succession Act 1925. Somebody was asking, yes, with regard to property and all that, Indian Succession Act is applicable to Christians as such. Then you move on to 28, which is about court may grant protection order. Okay. So if the wife is maintaining herself by her own industry, own effort, or own property, she may make and give to the wife an order protecting her earnings or other property from her if she has no. So खुद का मेहनत से कमा रही है, she has made some property, so that needs to be protected. Earnings need to be protected. Property needs to be protected from the husband. I don't know what this Uniform Civil Code will be doing with regard to all this, but I'm sure there'll be discussion, deliberation, and all these sensitive issues as such. And also creditors, person claiming under it, all of that is provided here. Then 29 would talk about discharge or variation of orders. Okay. If desertion is seized or any other reason it thinks fit, it may discharge or vary the orders. So because of such provision, there are application preferred left and right. Then application needs to be contested. Court needs to hear the parties, and the litigation keeps on piling up. Easy way out or the best way out in the interest of parties as well as the advocates in long term is that you encourage mediation and you yourself get to know more about mediation. Many advocates, uh, I, I have to tell you, this morning my uh, guru, Sir Popat, Sir Popat, he has messaged me and passed on this link to others also. So I remember this mediation very well, his teachings and what he shared with us. It is so very important in the present time, not only to reduce the backlog, but it is also necessary. I am told that one of the Khoja community is a Muslim. Not one of them takes a litigation to the court. If something like this could happen, it would be a wonderful thing happen. If not all, at least majority of the litigation, they need not be carried to the court. Mediation can happen as such. Okay. Moving on further, uh, this section 30 will talk about liability of husband seizing wife's property after notice of order. So husband or any creditor person claiming under the husband they seize or continue to hold any property of the wife after notice will be liable. That is what it says. He would have to return or deliver the property to her. So very clear and pay her some equal to double its value. Any provision made, like I keep saying, civil CPC, The Britishers have given it the CPC and have moved ahead. We have, of course, the Arbitration Act where CPC does not apply. The Indian Evidence Act does not apply. And the deadlines are in place and things move very fast. But we are stuck with it all. I don't know whether I should call it archaic, though there are amendments which have happened from time to time. Also, Section 89 encourages the reminded that the court should see whether there are terms of settlement which could be formulated and given to the parties, and they can give their suggestion, and the matter could be nipped in the bud as such. So all these provisions are very much there, okay, in CPC. But then this very thing which was there to facilitate the administration of justice, so as to make this maxim real, we just be remedium. Wherever there's a right, there's a remedy. In order to for a person to avail this remedy, the CPC is made. But today, this very CPC has become a big obstacle in matters getting disposed of fast because of the misuse or the provisions of CPC as said. Okay, so some lengthy discussion, elaborate discussion on this some other time. Moving on to section 31. Wife's legal position during continuance of order. So long as any such order of protection remains in force, wife would be deemed to have been during such possession of her in the like position in all respects with regard to property, contracts, suing and being sued as she would be under the Act if she obtained a decree of judicial separation. So position does not change as such. The head note of that section itself makes it very clear. Okay, then you have restitution of conjugal rights. This section is also very clear. If the husband petitions for this restitution of conjugal rights with the object of getting rid of prior maintenance order, then the petition would get dismissed. That is what is held in Solomon Selvaraj versus Chandriya Mary as such. So misuse of provision as such. Okay. So we are quite familiar with this provision. There is no legal ground why that application should not be granted. Then decree of restitution of conjugal rights will be uh, uh, can be preferred as such. This marriage litigations, so many different litigation can be preferred, becomes a heaven for advocates or looking for such a prey. But that is not the way it should be. We are required to act in a very responsible way. Coming back to another case law, Kalpala Babu Rao versus Kalpala Ammaji. Here, the petitioner's husband, he had made an unfounded allegation that the children of the wife were born to some other person, not to him. Court held the charge was reasonable excuse for the wife to defend herself, since the charge amounts to cruelty to her. So any such charge, wild allegation, you should not get into. Uh, okay. If you have allegation only against the mother-in-law, make it only against the mother, not against the husband. That may help save the marriage also. So before you make allegation, don't make all of them parties and prolong the litigation endlessly as such. Then the other side would perhaps come to the High Court to cause the matter or drop another party. That itself will prolong the matter. That's it, which is not in the interest of parties, and that is not what we are required to call to do. Okay. What would reasonable excuse mean? It would be in accord with reason, just and fair in all the facts and circumstances of the case. Okay, that is what was held in one of the case laws as said. Okay, so reasonable excuse will depend on the facts and circumstances of each case. It should be not just any excuse, it should be just excuse, it should be a rational excuse, it must be sufficiently weighty and convincing. That is what it says. Okay. So then you have provision regarding damage and cost. Section 34 would talk about husband may claim damages from adulterer. Okay. So the head note itself is very clear. Okay. 34, that is repealed by this Amendment Act 2001. Okay. So, yeah. Uh, while granting the decree of divorce in favor of the husband on account of wife's adultery, court can also grant damages. That was held in one of the cases, but that case law is as old as somewhere in 2001 itself. No? Then you have power to order adulterer to pay cost. That again is deleted. So quite a few sections are deleted with the amendment of 2001. So it will perhaps help you to look at 2001 amendment, what all things have happened in 2001. The 35 will talk about power of order to order adulterer to pay cost. The person who is responsible for all this, court can settle cost on him, provided that correspondent will not be ordered to pay the petitioner's cost if at the time of adultery they are living apart from a husband, leading the life of a prostitute, or if the adult reason to believe that respondent, okay, I'm sorry, I'm on 35.2. The correspondent had not at the time of the adultery reason to believe the respondent to be a married woman. All of that would disentitle him. No? Then your power to litigate intervener to pay cost, that also provision is made. So pay the whole or any part of the cost occasioned by the application, that provision is made. Okay. If the husband himself is guilty of adultery, then he would have a no right to cause against the correspondent. Obviously, so that is held in another case law. Then you have this provision of alimony. Okay. Uh, Alimony pendenti lite. That means pending litigation. If any suit under this act, whether it be instituted by the husband or wife, whether or not she has obtained a decree of protection, wife may present a petition for expenses of the proceeding. This is with effect from 24/9/2001. And alimony pending the suit. Okay. So for payment to the wife of expenses of the proceeding, alimony pending the suit, as it may deem just, all that is there. Provided petition for those expenses, proceedings and alimony pending suit, as far as possible, it should be disposed of within 60 days, but we know how the courts are overburdened with all such litigation. So there was this important amendment happened in 2001. Wife can now claim expenses of the proceedings also, which hitherto before 2001 she was not able to. Also, the proviso limited the maximum amount of alimony earlier to 1/5 of the husband's average net income for 3 years next preceding this. That is gone now. Okay. Uh, okay. There should be no such limit now. Ultimately, this amendment act has come about. The proviso itself is gone. Thirdly, petition under this section required to be disposed of within a period of 60 days. I foresee some question on this section 36. So not just a hunch, but I really don't know. But I feel something could be asked. If I were the examiner, perhaps I would have been tempted to ask something on this because old law was something different and the new law is different. Okay. So only the wife would be entitled to alimony pending lite. Okay. So language of the section is very significant. Does not disentitle the wife who has been independent means of income seeking relief under this section, even though she may be earning. That does not preclude her from claiming relief under this section as such. There's a case law to that effect. Okay, Joy Kuti Matthew versus Valsama Kuruvilla. Okay. This provision, as we know, it differs from Hindu Marriage Act, wherein even the husband has a right to claim the expenses of the proceeding and maintenance pending lite. So, if you have to boast about some better provision in some other law, there should be one such provision where you can point out this is lacking to this extent. There, the remedies available to both such arguments you can have when you want to have a personalized argument trying to defend certain laws and attack certain laws. Okay. But I think Uniform Civil Code is trying to go beyond all this and to have some kind of acceptability amongst all. Okay. Uh, then, uh, yeah. Okay. Moving further on, I'm looking at some where laws can help. So when the court would make order of interim maintenance to be payable from the date of application, there it was held that there is no jurisdictional illegality as such. So to warrant intervention by the High Court in some particular facts of the case, it was held so. Then you have provision with regard to permanent alimony as given in 37. Section itself is very self-explanatory. Okay. If the court is satisfied, okay, then such a order would be passed, okay, to secure to the wife such gross sum of money and such annual sum of money for any term not exceeding her own life, and regard would be had to her fortune, if any, to the ability of the husband and to the conduct of the parties. All of that is there. All the details are contained in this. No? So, with regard to this, when this petition for dissolution of marriage is dismissed, then the permanent alimony cannot be granted because in the marriage between the parties, it subsists. No? Obviously so. Okay, in another case law called Daniel Anand versus G.N. Sujata, where the High Court permitted this permanent alimony in support given to wife under this provision post divorce, that was to ensure that decent life to that wife has set. No? Now, what would be the relevant factors to be considered while granting permanent alimony? Financial conditions, standard of living, length of the marriage, age of the parties. I was handling some case where one of the parties was a foreigner, There, minimum 6 months the parties have to live together. Only then one can claim alimony and all of that. So there the laws are different. So as I was saying, what would be the factors? Financial condition, standard of living of the parties, length of the marriage, age of the parties, physical condition of the parties, ability of the person to support the recipient, and all of that. Okay. So uh, court would have the power to make an order for payment of larger sums by the husband if the circumstances justify an increase in the amount of alimony. So those powers are also there. 38, you would have court may direct payment of alimony to wife or a trustee. So this section is also very clear. If they expedient to do so, court would grant. A new trustee also could be appointed. Section 39 is about power to order settlement. Okay, this is coming from English origin. Okay. The section 39 is deleted by the Divorce Amendment Act 2001. This section conferred power on the court to settle the property of the wife for the benefit of the husband and children. Okay. Section 40 is there. Inquiry into the existence of antenuptial and post-nuptial. There could be agreement before marriage and after marriage, anti and post, before and after. So all that would have to be taken. What the party seeks to give and seeks to take, all that would have to be taken into consideration. Okay. Uh, so, yeah. And therefore, it is open to the party to make an application under Section 40, but that application should not be easily given into unless special circumstances exist. Makes it just and proper to make an order upon an application. Okay. With regard to settlement. Okay. Then you have Section 41, custody of children. So long as the child remains a minor, 41 to 43, court would have the power to make that order regarding the child as such. Okay. Uh, uh, there are so many cases you all may have handled, okay, with regard to the children, sensitive matters. Okay. What is the consideration? The controlling consideration governing the custody of the children is the welfare of the children, not the right of their parents. Keep this in mind. I like this, what was held in one of the cases. It is coming across through Rosie Jacob versus Jacob A. Chakra Makal, no? Somewhere in 1973. But you are not talking about the rights of the parent. It's all about the child. One has to keep that in mind, not about the parents so much. Of course, parents' rights are also involved, but cannot deny that. Okay. So then uh, 60 days time frame is incorporated by virtue of that amendment 2001. I'm not so happy with question being asked on how many days and all that, but it all depends on how the examiner wants it to be. 42 is all about power to make orders after decree as such. Okay, if necessary, then with regard to children under the protection of the court, required custody would be given to the neither the court would take the custody of the child. Okay, all interim orders and all that can be passed. There's a provision in 42. 43 talks about powers to make orders as to custody of children in suit for dissolution and nullity. Okay, so here also any suit for obtaining dissolution, marriage, or decree of nullity, okay, of marriage instituted in a district court could make from time to time before making a decree interim orders, okay, as it deems proper. The power is there with the court, okay, so that children could be placed under the protection of the court also. Uh, then you have 44, which talks about power to make orders after decree of confirmation. Okay. Something similar is there. So children under the protection of the court, or as might have been made by the decree absolute or decree or by such interim orders, all those terminology is there towards the end of that section 44. Anything not understood in that section, you are free to come back on this and ask. Then you have 45. I have made a mention of this. Subject to the provision contained herein, all proceedings under this act between the parties and parties shall be regulated by the CPC. No, that's where the devil lies. But then there are provision, if you have understood the Family Courts Act properly, matters can be disposed of based on affidavits as well. So yeah, then it is saying subject to the provision. I've already pointed out Section 8, where High Court is given the power to transfer matter. So that is one such instance where I pointed. So counterclaim is not allowed under India Divorce Act uh, and cannot be made under CPC. Counterclaim is not allowed under this act. You cannot say CPC provide. Therefore, I'm making as such. Whatever is there, you have to take it up there itself as a matter of defense. 47 talks about petition to state in the absence of collusion that we have seen. There is not any collusion or connivance between the petitioner and the party. then statements would have to be verified. Obviously, so you cannot make any statement in the air to verify. Collusion, you have to make that statement is mandatory. Okay, and all the circumstances would have to be taken into consideration. Okay, whether a reasonable inference should be drawn that there was collusion or not. There is some case law to that effect. Then you have suits on behalf of lunatics that could be brought by or on behalf of the committee or other person entitled to his or her custody. Then you have suits by minors can be brought. uh, Here it says petitioner is a minor, he shall sue by his or her next friend. We know next friend doesn't mean another minor, it means some adult who is taking the responsibility of the child, and that has to be approved by the court. Okay, and yeah, then you have service of petition. 50 will talk about it. So petition would have been served on the party to be affected thereby. So there is no uh, hide and seek or hit and run kind of. Other side, it is a kind of civil proceeding. So CPC applies and all of that. Therefore,
Sir,
सर थोडा टेक्निकल प्रॉब्लेम झालाय.
चलो. अनम्यूट त्यांचं कर
Ah, okay. I'm
त्यांचं
almost,
कर त्यांचं कर
yeah. I'm almost at the fag end of the.
सर हा झालं ना
Yeah. I think I'm audible, right? Honorable members, kindly respond. I'm audible, right?
हाँ सर
येस येस
I'm on the fag end of the lecture. Here, 51, we're talking about mode of taking evidence. No witnesses in all proceedings where the attendance can be had, they would be examined orally. Any party may can offer himself herself as a witness. They would be examined, cross-examined, re-examined like any other witness. There's a provisor to it. It talks about when the parties, they can give an affidavit. But so far, the deponent in every affidavit is concerned, on the application of the opposite party or a direction of the court, you would be subjected to cross-examination. Affidavit is not taken as a gospel truth. You would have to be cross-examined. And after that cross-examination, could be re-examined also. 52 is about husband and wife are competent witnesses against each other. Okay, they can give evidence of and relating to that cruelty or desertion. That comes across in 52. Okay, 53 is they have used the word closed doors, where we other legislations have used the word camera. So whole or any part of the proceeding under this act can be heard if the court thinks fit with closed doors, so that same as camera. Not anybody and everybody would be allowed. Then you have power to adjourn. Simpliciter, it says any petition under the act require further evidence. It can be adjourned, time to time adjourned. So 50,
है ना हाँ बस
55 would talk about enforcement and appeal from orders and decrees. So there's a provision for appeal. Okay. Just as you would appeal a decree or order of the court made in excess of ordinary civil jurisdiction, an appeal would lie here. Okay. No, there would be no appeal on the subject of cost alone. That is what it says. Okay. Then move on to the last legs of all this. Okay. That Indian Divorce Act 2001, it has repealed that first proviso, which I did not comment more on that. No. So yeah. Then going further, 57 talks about remarriage. There's a specific provision. Uttar Pradesh also there's an amendment. Here earlier, this section, this 57 has completely revised. No? And that earlier provision, which was cumbersome, that is gone. Now here, if there's a decree for dissolution or nullity of marriage which is passed, and either the time for appeal has expired without an appeal, has been presented to the court, including Supreme Court, or appeal has been presented but has been dismissed, and the decree or dismissal has become final, then it shall be lawful for either party to the marriage to marry again. So appeal time is over or appeal is dismissed, then parties can remarry. Okay. Then where appeal has been dismissed and when the result thereof marriage declared to dissolve, but no sooner it shall be lawful for respective parties to marry. Okay. Earlier, tie of marriage was not completely dissolved until the lapse of 6 months. It is not so now. Okay, this present provision 57 is similar to what is there in Parsi Marriage Act, Parsi Marriage and Divorce Act, Section 48 similar to Special Marriage Act, Section 30 and similar to Hindu Marriage Act, Section 15. Okay, then you have Section 58. It talks about English clergymen not compelled to solemnize marriage of persons divorced for adultery. Can force the clergyman with respect to his beliefs. So, okay, that is what it says in essence. Then you have 59 talking about English minister refusing to perform ceremony to permit use of his church. Okay. Then he will have to permit any other minister in the holy orders, any other person, any other clergy to of the holy orders of the said church entitled to officiate within the diocese. Diocese is the area within the
रिसीव करो
diocese
मेरा दुपट्टा
or chapel. Chapel is a small worship place of worship. It says that word is used there in 59. Then you have Section 60 talks about, it's a miscellaneous thing almost there, and decree for separation of protection order valid as to person dealing with wife before reversal. Section itself is very self-explanatory. Talks about indemnity of person making payment to wife without notice of reversal of decree and protection also. Head note is good enough for you to know. No questions could possibly be asked on that. Hopefully no. Then 61 talks about bar of suit for criminal conversation. After this act has come into force, no person competent to present a petition under 2 and 10 shall maintain a suit for criminal conversation with his wife. Okay, so that is there. Then you have, that is the end of it. Then you have scheduled various forms. I would like to take any questions I'm told there are no questions. So I will call it a day if there are no questions. If there is any, you are free to ask me. My number also is known to you all. I'm in the group as well. So feel free to ask. I think I should wind up now. I've taken more than required time, but I thought of doing a good job of it. Okay. Yeah, esteemed bar
Thank you,
council
sir.
members.
I don't see any questions.
Okay.
Uh,
It was cumbersome, I don't know, but it was necessary to deal with each and every section, because when I see your papers, I've taken hard copies, I've dealt with all of the questions which are there in your papers, and I don't see any difficulty that they would face in answering any of the questions. Okay, you have sent me 2014, 15 questions, and also 2010 ka, 2017, 18 as well. All of that, all the questions which have been asked there, I've dealt with and clarified. And by now they
yes,
must have got answer. Yeah.
yes, sir.
Okay.
Uh,
Somebody requesting for circulating those papers.
the papers will be circulated.
Okay.
In
Yeah.
fact, there will be one discussing on the papers. So
Correct.
that will be the papers will be circulated
Correct. Yeah.
in the group. Uh,
Thank you. Thank you
Sonali,
so
you
much.
can take the vote of thanks.
That's fine.
Sonali,
Yes, ma'am. Yes, ma'am. It's my
yeah,
pleasure
please take the
to
vote.
propose vote of thanks on behalf of Bar Council of Maharashtra and Goa towards today's our chief guest, Advocate Prosper D'Souza sir, for enlightening our knowledge on Divorce Act. And I also would like to thankful to the coordinator of this lecture series, Dr. Uday Varunjikar sir. I would like to thankful to chairman and vice chairman and all the respected members of Bar Council of Maharashtra and Goa. And last, to the all participants who is participated in this lecture series. Thank you all of you.
Thank you so much. Thank you for giving me this opportunity. God bless you. Take care.
Thank you, sir.
I'll leave this meeting with your permission.
Yeah, yeah, yeah.